In 2023, two New York attorneys filed a brief citing 6 court cases. Every single one was fake. ChatGPT had invented them. The attorneys were sanctioned, fined $5,000, and became the cautionary tale every law school in America now teaches. This video shows you exactly how smart lawyers are using ChatGPT today. Without becoming the next case study, most lawyers are asking the wrong question. They ask, "Can I use ChatGPT?" That's not the real question. The real question is, how do you use it without creating confidentiality problems, competence issues, or disciplinary risks? And here's the surprising part. Most ethics guidance isn't telling lawyers to avoid AI. It's showing them how to use it responsibly. Stay until the end because I'll show you the simple 4-step framework experienced attorneys are using before every single AI prompt. It's practical, it's easy to remember, and it may completely change how you think about legal AI. The pressure on lawyers has never been higher. Clients want faster responses. Competition is increasing. Administrative work keeps expanding. At the same time, AI tools can summarize documents, organize information, draft content, and identify issues in seconds. That's the opportunity. But here's the risk. Many attorneys are experimenting with AI without understanding that the ethical rules never disappeared. In 2024, the American Bar Association issued Formal Opinion 512. The opinion made something very clear. Lawyers using generative AI still have duties involving competence, confidentiality, supervision, communication, and candor. ABA Model Rule 1.1 requires competence. Rule 1.6 requires confidentiality. Rule 5.3 covers supervision of non-lawyer assistants. These 3 rules are exactly what bar associations are examining when AI complaints come in. The technology is new. The professional obligations are not. That's why this isn't really a technology story. It's a professional responsibility story. The attorneys who get into trouble aren't usually the ones using AI. They're the ones using it carelessly. And once you understand that distinction, everything else starts to make sense. The biggest myth in the legal profession right now is that using ChatGPT is automatically unethical. That's simply not true. In fact, the ABA's first formal guidance on generative AI didn't tell lawyers to stay away from AI. It explained how lawyers can use it while still complying with existing ethical obligations. The issue isn't whether you use AI. The issue is how you use it. Think about email. Email isn't unethical. Sending confidential information to the wrong person is. AI works the same way. Smart lawyers remove identifying information before submitting any prompt. Names, addresses, case numbers, sensitive client details. Instead of saying, "My client John Smith was arrested in Tulsa on March 14th," they say, "Analyze this hypothetical criminal defense scenario involving a warrantless search." Same objective, dramatically less risk. The goal isn't to avoid AI. The goal is to protect the client while using AI. Those two things can coexist. Quick test. Imagine opposing counsel projecting your exact prompt onto a courtroom screen. Every client detail, every fact, every piece of sensitive information visible to the judge and jury. If that image makes you uncomfortable, rewrite the prompt before you hit enter. Here's mistake number 2. Treating AI output as finished work. That is where real problems begin, because ChatGPT can be persuasive and wrong at the same time. The Mata versus Avianca attorneys learned that lesson the hard way. They believed they had found supporting precedent. What they actually found were completely fabricated cases generated by AI. The court later concluded that basic verification would have revealed the problem immediately. This is exactly why smart lawyers never delegate judgment. They delegate drafting, brainstorming, issue spotting, organization, summarization, but never legal judgment. Think of ChatGPT as the world's fastest junior assistant. Helpful? Absolutely. Trustworthy without supervision? Never. Every citation gets checked. Every quote gets verified. Every legal conclusion gets reviewed. Because when something goes wrong, nobody blames the software. They blame the lawyer. And ethically speaking, that's exactly how it should work. So far, we've covered confidentiality. We've covered hallucinated cases. But here's the bigger question. What separates the attorneys getting tremendous value from AI from the attorneys ending up in judicial opinions, ethics seminars, and legal headlines? The answer is a simple four-step framework, and once you see it, you'll start applying it to every single AI interaction going forward. This captures the themes appearing again and again in ethics opinions, bar guidance, and court discussions about AI. Four steps: sanitize, verify, supervise, document. Step 1. Sanitize. Before using AI, remove identifying information whenever possible. Know exactly what you're sharing. Never assume the tool knows what should remain confidential. That responsibility belongs to you. Step 2. Verify. Every factual claim gets checked. Every citation gets checked. Every legal conclusion gets checked. Verification isn't optional. It's the entire difference between responsible AI use and reckless AI use. Step 3. Supervise. The final work product belongs to you, not the software, not the AI company, not the vendor. You. Treat AI output exactly like work produced by a non-lawyer assistant. Review it, challenge it, correct it, own it. Step 4. Document. Create an internal process. Know when AI can be used, know when it cannot. Know who reviews outputs. Know what information should never be entered. The lawyers with the fewest problems tend to have the clearest procedures. Not because they're paranoid, because they're prepared. Let's make this practical. One solo attorney uses ChatGPT to turn a 300-page deposition transcript into a one-page chronology, then reviews it personally before using it. Another uses it to generate 20 possible contract issues before conducting traditional legal analysis. Another creates a first draft client newsletter in minutes instead of an hour. Another organizes discovery requests into categories for easier review. Notice the pattern. None of these lawyers surrendered judgment. They used AI to eliminate repetitive work. Then they applied professional expertise to the output. That's where the real value comes from. Not automation, augmentation. Remember the question from the beginning? What are smart lawyers doing differently from the attorneys who got sanctioned? The answer is surprisingly simple. They're exercising judgment. AI generates possibilities. The lawyer determines what is true, what is relevant, what is persuasive, and what ultimately leaves the office under their name. The lawyers succeeding with AI aren't replacing legal expertise. They're protecting it. That's the real secret. Not avoiding AI, not blindly trusting AI, using AI responsibly, with verification, supervision, and accountability at every step. Next video, we're breaking down the exact AI stack that lets a solo practitioner compete with firms 10 times their size for under $150 a month. Subscribe to Legal AI Labs so you don't miss it, because the future of legal practice won't belong to lawyers who ignore AI. It will belong to lawyers who learn how to use it wisely.